Yes.
Please note, yesterday when we adjourned, there was a debate as to whether Mr. Ramusipili can use photos that were obtained pursuant to an investigation in the second docket, First Lawrence Cast 3751 of 2019. We raised an objection. We subsequently had a conference with the defense regarding those photos, and Mr. Ramusipili has indicated that he will no longer be using those photos, subject to confirmation by him. However, my lord, we just want to sound a warning to my colleagues regarding the use of statements either in this docket 63610 of 2014 or in 3751 of 2019. There's a tendency to quote passages of statements in either of the dockets, but until now, out of this main docket, 63610 of 2014, and invite Brigadier Gwininda to comment on what those witnesses are saying. We submit, my lord, that that is improper. You cannot use, as we've objected yesterday when Mr. Ramusipili was quoting passages from some statements and eliciting the comments of Brigadier Gwininda. You cannot use inadmissible evidence in cross-examination. The only way, my lord, to use such statements is if the defense signal their intention to call those witnesses. But unless they do that, my lord, that remains hearsay evidence. And in this regard, we just want to briefly refer to the Handbook of Detour Criminal Procedure under cross-examination on page 22 to 54, when it deals with cross-examination and re-examination of witnesses. He writes the following regarding the use of inadmissible evidence, and he says, cross-examination based on inadmissible evidence is not permitted. And he then lists the categories of such inadmissible evidence, and amongst those categories he refers to an unproven document which the witness also cannot prove. And he quotes then the case of Howard versus Decker, Vetcop and Agencies, and Forwest Estate Pty Ltd and Sousa, 1971, volume 3, essay 937T at 948E to H. We had a look at that case. It's an old case, 1971 case, and it's the decision of the then Transvaal Provincial Division. It was a civil case, but the principles are still equally applicable. And in the heading, it says, where the party against whom a private document, in this case a private document, was applicable, but the principles are equally applicable to a criminal case. Where the party against whom a private document, in this case a deed of sale, not complying with certain requirements, is sought to be relied on, has neither been admitted nor its authenticity proven, nor that the contents thereof are correct. Its contents cannot be used either as evidence or for the purpose of cross-examination. And proving the authenticity thereof, my lord, entails calling the deponent of that document to identify it. And in this instance, paragraph G, even though it was a private document, the court referred to in paragraph G, and we quote, the law in relation to the proof of private document is that the document must be identified by a witness who is either, one, the writer or signatory thereof, or secondly, the attesting witness, or thirdly, the person in whose lawful custody the document is, fourthly, the person who found it in the possession of the opposing party, and fifthly, a handwriting expert, unless the document is one which proves itself, that is either produced under a discovery order or may be judicially noticed by the court, or is one which may be handed in from the bar, or is produced under a subpoena, duces tecum, or is an affidavit in interlocutory proceedings, or is admitted by the opposing party. So in other words, my lord, the rules of admissibility of a document must first be satisfied before a document can be used in cross-examination. And this applies to all the statements in this matter, as well as the statements that were made pursuant to an investigation in First Lawrence Case 3751 of 2019. We don't want to disturb the flow of the proceedings by standing up and objecting every time. Hence, my lord, we just felt that we just need to bring this to the attention of my colleagues. Thank you.
Okokuqala ke udaba lokuqala umshusha akhulume ngalo ukuthi ke nanjengoba izolo ke bekunale ithombe lezi zasepark uMr Msipile ebefisa ukuthi ke abuzeke ngazo kodwa ke baye bahlangana ke izolo ke umshushisi nabameli bakhuluma wasesho ke uMr Msipile ukuthi cha akasaqhubekike ngalezo ithombe lezo ukuthi abuzeke imibuzo kuzona. Okwesibili ke uyakuthi nje ufisa nje umshushisi ukuthi ke exwayiseke ozakwabo mayelana nokusebenzisa ke izitatimende abantu bazo abangezanga noma abangabizwanga la enkantolo bazosho ukuthi izitatimende zabo okusho ukuthi ke leso statement leso asikabikho isiqinisekiso ukuthi ke kukho ke ngokomthetho noma ngokwendlela ke okwenziwa ngayo enkantolo ukuthi kusetshenziswe istatement bese kulindelwa lofakazi ukuthi ke aphendule kwistatement ekungesona esakhe futhi nomnikazi waso istatement leso engabizwanga enkantolo ukuthi ke azosiqinisekisa mayelana nalokho okubhaliwe kusona.
Yes, Mr. Ramsepi.
As the court proceeds, my lord, I note the submission by my learned colleague, my lord. However, I cannot respond at this stage, my lord, because I did not go and prepare for that. I'm busy preparing for the application. If I need to respond, my lord, it will have to be tomorrow.
I don't understand. Yesterday we said you should prepare.
No.
Both of you. Or
No,
not even both, all of you.
No, the court said we can either discuss it amongst ourselves or prepare. Or prepare.
Yeah, that's what I said.
Yes, or prepare, not discuss and prepare.
How do you prepare without discussing?
No, the discussion was whether is it necessary to prepare for this argument pending that I'm going to use the statements or not. But once we decided that I'm not going to pursue that line of questioning using those photos, we then decided amongst ourselves that preparation is no longer necessary.
I see.
Yes.
So you're saying, I don't want to prejudice your client. Did you want to use that information? Let's start there.
It is not material for my cross-examination.
Well, now, why did you bring it to court and...
My lord, I specifically stated why I brought that information to court.
Oh, okay, fine. What was the reason, by the way?
My Lord will recall, I don't know which witness was it during the main trial. Reference was kept on mention of the park, the left 200 meters.
Yes.
And the court asked my learned colleague, Mr. Baloyi, that it's imperative that the court has sight of the photos of the park and the surroundings. And in light thereof, my Lord, I think the following day, Mr. Baloyi came and furnished all of us with disclosure regarding those photos and the album and the statement of the person that took those photos. However, my Lord, that was not pursued thereafter, and the court never inquired further. But then, as I was preparing, my Lord, like I said, I came across those photos, and it was just to remind the court that the court once asked for these photos. Is it also necessary now to have that witness come and testify to orientate the court as to the park that was searched by the community, by the first responders, where it is alleged that the intruders ran, which is 200 meters away from the scene? That was the purpose, man.
Yeah, it's obvious the court wanted to know if there were photographs of the scene. And the answer then, because it was silence, I thought no photos were taken.
It is unfortunate, but because we were furnished, my Lord, with the photos the following day, after the court.
And you never brought that to the attention of...
It was never brought to the attention of the court.
Now the question is, do you want to use them, sir?
No, I'm not going to utilize them, my Lord.
Because I don't want it to be said that you are being refused, and your client is being refused an opportunity to use those photos, which were supposed to be part of his defense.
Yes.
Are you with me?
I am, my Lord.
Yeah.
And I did discuss it with him this morning to say I'm not going to utilize the photos because this was the context within which I was bringing it to the attention of the court, and he is well versed, my Lord, that I'm not going to use those photos anymore.
Let's hear your colleagues, Mr. Nisi.
Thank you, my Lord. The prescription, which is of a blanket nature, my Lord, that the state seeks to impose on the defense with regard to the usage of certain statements, tends to be unlawful, and from where I'm studying, it's a bit rational, because it does not take into account the provisions of the Law of Evidence Amendment Act number 45 of 1988, which amongst others stipulates that information that is contained in a document or information that is contained in a statement may be admitted on a provisional basis, where the person who seeks to use that information undertakes to call the person whose property value the content of such statement lies. So the person who wants to use that statement can simply make an application to court and say, my Lord, may I please be granted the leave to use the content of the statement, because later on then I will call the person upon upon whose credibility the content of this document lies. There's nothing wrong with that, my Lord. That is just point number one. Point number two, my Lord, is the state makes a disclosure. Upon investigation, or let me actually start it here. The state receives a complaint that is investigated by police. The police go out and take statements from certain witnesses. Then the matter gets brought to court, and there's a trial such as this one. And the state makes a disclosure. In the process, circumstances had arisen in these courts, and in certain circumstances may also arise. I've also done this as well. Then you go to the list of state witnesses. Amongst the list of state witnesses is a particular Mr. X, maybe he's witness number 5. And then they call the first witness, the state calls his first witness, and then the process of cross-examining that witness, who's witness number 1, and then you refer to the statement of witness number 5, who's also mentioned in the list of state witnesses. For instance, you come and say, Mr. Witness, Brigadier Kininda, the state is going to call Mr. X, who's witness number 5, who's going to say, amongst others, this and 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 this. I'm not even so sure, my lord, whether that is unlawful, because the person that has been referred to, who the defense believes that later on will be called by the state, is amongst the list of state witnesses. So there's perfectly nothing wrong with that, my lord. Unless if the state from the beginning indicates that these are the specific names of witnesses that we are going to utilize in trial, the rest we will not be utilizing. It is therefore upon those bases then we can approach the court and say, on the basis of the fact that the state is saying that they will not be utilizing this witness, may I then be granted leave to provisionally use the statement, because most probably this information is very important for the defense of the accused person. I may call these witnesses in our defense, and then the court provisionally then allows the usage or the content, the usage of the content of such a statement, my lord. But a blanket prescription that such documents cannot be used, my lord, I think it's unlawful and it has to be rational. What should actually happen is it should be a case-by-case determination. It should not be a blanket amnesty. I therefore do not align myself with the suggestion or with the application by my. I don't know whether it was an application, but I heard him saying that he was sounding a word of advice. I don't align myself with that advice, my lord. I may say from the bar that I'm not inclined to accept that advice. Thank you, madam.
Okay. Yes, Mr. Ngumalo.
As the court pleases, my lord, before Mr. Ngumalo addresses the court, I was called by my client to indicate that, my lord, the application or submissions by my learned colleague, my lord, are one-sided.
A what?
Are one-sided, because, my lord, he tells me that Brigadier Kininda has referred to the statement of Absolom Zungu, which he says links accused number 1 and 2. Yet that Absolom Zungu, the state did not call, and they led evidence to that effect. The evidence of Magaleni, who's the deceased, who describes suspect B, which the state alleges is accused number 2. Also, that person was never called. We have not been furnished with the death certificate of that person. So what he essentially says is that the state may be making this application, but what is good for the gander is the warning that he sounds to us, he must also sound it to himself. As the court pleases, my lord.
Yes, sir. Mr. Ngumalo.
My lord, the use of hearsay evidence is governed by Section 3 of the Law Amendment Act 45 of 1988.
Is that true?
Sorry?
Is it true or correct to make that statement, that hearsay evidence is governed by the Evidence Act, Section 3 of Act, the 45 of 1988?
There are various, I think there's about 7 requirements that must be met before one can.
Yeah, that's why I'm asking, is it correct to say hearsay evidence in this case? Because according to what I understood from Mr. Baloi, those witnesses are alive. In terms of the Criminal Procedure Act, they must either be dead or missing.
Yes.
So that the court can find that in that instance, that evidence could be admissible in the interest of justice. But that's why I asked Mr. Ramsipiri yesterday, this gentleman who compiled the photographs, where is he? He's still alive. And he never answered me. Just said, oh, well, you know, I don't know. So I couldn't make a ruling then. Okay, go on.
No, I was also going to address the court on the basis that if the court is forewarned that the credibility of that evidence upon whose property value relies is going to be called, then that evidence may be provisionally
Yeah, quite. Right.
admitted pending the calling of that witness. And in the event that witness is not called later, then that piece of evidence may be removed from the record.
Fine.
That's how I understood it.
Yeah.
So if the court in any proceeding, for instance in this case, is warned that the counsel is going to use an affidavit and this person is going to be called, then the witness may be cross-examined on the basis of the content of that affidavit. If the court is forewarned, then failure of the counsel in calling that witness that was referred to earlier, then that evidence is scrapped from the
Okay,
record.
fine.
That's how I understand the whole
Okay.
procedure. Thank you.
Yes, Mr. Mshola.
My Lord, yesterday when we adjourned, the court granted us the indulgence to discuss with the state regarding the status of the content of the docket 375. My Lord, we did discuss the status of that docket, and the state indicated to us that since it was discovered by the state to us and we are in possession of that information, it can be used by the defense. Secondly, my Lord, it is the duty of each and every counsel who is intending to lead evidence on a particular statement, if the author or the deponent of that statement is no longer alive, to inform the court and bring the necessary application in order to be able to use such statement when cross-examining, especially this witness who is the investigating officer in this court. As a result, my Lord, my submission is that since we have been given that permission to proceed, as the time when comes when the counsel intends to lead evidence on a certain particular statement, each counsel knows the procedure, my Lord. That's my submission.
Yeah, but I thought here we're speaking about photographs, documentary evidence. Is that not so?
Yes, my Lord. My Lord, the photographs, unfortunately, my learned friend has decided not to proceed with that. However, the state had indicated that if he wants to lead the evidence regarding that statement, he can still proceed, my Lord. And we also ask the state to make those witnesses available to us if the state is not intending to call them. And the state indicated that as soon as we indicate, the witnesses will be made available.
Okay.
Yes. Therefore, whenever counsel is or intends to lead that photo album, especially in my case, I will be calling that witness who took that photo album, and I will be using that photo album.
Is he alive?
He is alive, my Lord.
Where is he?
Mr. Kininda can get it. No, my Lord, the investigating officer will be approached when we are about to lead that information to get the whereabouts of the witness for us. Because once the state has finished with its state case, he will make those witnesses available to the defense, and the investigating officer will get them for the defense. And then we'll be able to call them, all of them, my Lord. We are going to give them a list of all the witnesses that the defense intends to call.
Okay, fine, no problem. Yeah, that's a general proposition. This court is obliged. I've listened to the defense and even the prosecution. The government of this debate is the fact that Mr. Ramsipili wanted to utilize photographs which apparently are the result of an investigation by the state in another case. And I think Mr. Baloyi initially objected that, but after some time relented to say if Mr. Ramsipili wants to use that evidence, which is documentary evidence, he may deal with it as he wants. Am I quoting him correctly?
That's correct.
Right. Now, as we all know, the Constitution is the premier law in our country. What Mr. Baloyi stated about hearsay evidence is correct, legally, no problem. and also what Mr. Mnisi states about Section 3 of Act 45 of 1988, the Evidence Act, which came into being 1961. I'm sure all of us were born. It's correct. But there is a rider here. I asked, how was this evidence acquired by Mr. Ramasipidi? And Ramasipidi said it was apparently discovered by the state before this matter was nullified. Is that not so?
No, it was during this matter, the current matter, not before Justice Maumela. It was in this trial.
Oh, I see.
Yes.
Is that so, Mr.?
Well, and I don't want to cast aspersions on anyone. The main disclosure regarding 375 was done during the trial before Judge Maumela.
Yes, I think I listened.
Disclosing anything
That's it.
pertaining to and as say, my lord,
No, fine. I knew.
memory can sometimes leave us in the lurch.
Yes,
but
I listened to say this was discovered during.
Yes, but
I even said my predecessors.
yes, that is my recollection.
Yeah, quite. But it was not formally discovered at the beginning of this trial on the 17th of July, 2023.
No, 375.
Yeah, 375. I'm talking about 375.
Yes, was discovered during the proceedings that were aborted before Judge Maumela.
Yes, that's how I understood it. You don't agree, Mr.?
No, I don't agree, man.
You were all in court. I wasn't here.
My lord, how can that be?
I was sweeping the floors when you were sitting with my brother Maumela. I wasn't there.
But my lord.
And you can agree
Yes.
on this. You were there during Maumela's time. You were there, or you are here during my time.
But what, the essence of my submission was that the question emanated from your lordship, not just this moment.
Okay. Otherwise we'll waste the whole time. Yeah, okay, let me just settle it. In terms of our law, the Constitution, about Section 35, 1C of the criminal of the Constitution states that an accused person has the right to defend himself and to challenge the state's case also. Consequently, accused before court here, they have the right to challenge any piece of evidence. Like, for instance, because it has been discovered, this court doesn't have to inquire as to how it was discovered, because it appears that in any event, Mr. Ramasipidi wanted to utilize this evidence of photographs or an album. And I don't want this case, wherever it goes, they say this judge never dealt with this exigency. So I'm dealing with it now. When you decide not to use it, it mustn't be said that I refused you the opportunity to use it. Okay? Because my finding, as I say, is that your client has the right to defend himself. And then in section 151(2)(a), at common law also, there has always been a right vested in an accused to call witnesses on his or her behalf. And that the Constitution recognizes this right in section 35, and also the Constitution now guarantees every accused person, as part of the right to a fair trial, to the right to adduce and challenge evidence. And this principle was reiterated in the case of S versus Duma. It's an unreported KZP case number AR 141/14. Where it was reported that it is an irregularity if a judge or a court denies an appellant or an accused person an opportunity to call a witness in defense of so fundamental a right that if that happens, it vitiates the proceedings in the sense that he has been deprived of a fair trial right. And this applies to all the evidence, documentary or even evidence relating to videos, photographs, and verbal recordings, all evidence. And this was also repeated in the case of Ugwebu versus the National Director of Public Prosecutions, case number 86184/201, which judgment was delivered by my late brother, Classens, on the 28th of May, 2019. And at page 22, he says the court recognizes the right and that this right is underpinned by a right to a fair trial and entails that all available evidence, including evidence that would assist an accused in his or her defense, should be made available, all, irrespective of how that evidence was acquired or discovered. In S versus Maluleke, unreported case number CA&R 34/2013, which was finalized on the 1st of November 2013. The court at paragraph 60 confirmed that where the defense fails to call a witness whom he or she could have been called, it is open to the defense to request the state to make that witness available. And actually, to put it in its proper context, the state is obliged, if it doesn't utilize any witness or any document which pertains to a case in which the right to adduce evidence or the right to defend the state's case, that is by the litigant, the state is obliged to make that evidence available, whether it be, as I say, documentary, photographic, or through video material. So it's a legal question also that if the state is not in a position to call any witness, it is incumbent on the defense to do so if it so desires, in order to actualize the right to a fair trial and to adduce and defend evidence in terms of section 35(1)(c). This case is peculiar in the sense that this court finds that this evidence, which is apparently wanted to be used by Mr. Ramosepili, which pertains to documentary evidence of photographs which were allegedly acquired or taken in another case, it doesn't stop Mr. Ramosepili or any accused person to utilize that evidence, because the right to section 35(1)(c), in my view, it's more decisive than the right to the privilege which is supposed to be extended to any evidential material which is in the possession of the state. Because we must bear in mind that this evidence, we keep saying it's a case. It's not yet a case. 735, it's not a case. It's still an investigation. A case only commences when there's litis contestatio, meaning that it only commences after the state has placed or put a charge to an accused person and that accused person pleads. Only then does that evidence become evidence in the accepted way. Otherwise, still an investigation. So Mr. Ramsipili actually wants to use photographs which are pertaining to an investigation in another case. But I'm saying the right of his client to Section 3551C supersedes even the privilege which the state could claim or wants to claim. Okay. So if you want to use that evidence, you may do so.
As the court proceeds.
Inkantolo ifinyeza ke ekushoyo ukuthi ke ayivimbi banika ayivimbi umuntu futhi ke mayibheka ke nawo ke amalungelo umsolwa anawo noma eshilo ke yena uMr Ramsipili ukuthi akasaqhubekike nokusebenzisa lezi ayithombe lezi zasePark ngoba inkantolo isho ukuthi kuse uphenyo lola ngoba yithombe ke lezi eyingekho la kuleli cala kodwa zingaphansi kwakhe u375 kodwa inkantolo ithi noma kunjalo ke uma kuwukuthi yena ufuna uyisebenzisa inkantolo ayimvimbi ke kodwa yena ushilo ukuthi cha akuseyisona ke isifiso sakhe futhi ukhulumile nawe ke Mr Ntanzi ukuthi ke akasaqhubeki nokusebenzisa lezi ayithombe kodwa kukona ke lokho inkantolo ithi ayimvimbi ukuthi ke angaqhubeka noma wena naye ke ummeli wakho ayinivimbi uma ukuthi nifuna ukuthi niyisebenzise.
Okay, thanks. Yes, Mr. Ramsipi, any further questions?
As the court pleases, my lord. I mean, that's it. Now, Brigadier, yesterday I had started on an aspect of the description given by various people that were in the house, in particular regarding accused number 2. And that description is contained in the statements that they made on the 27th of October 2014, and for some of them, they are viva voce testimony also in this court regarding that description.
Yes, my lord.
Kuyiqiniso ke ukuthi ke ubuza ke izolo mayelana ke nendlela ofakazi noma abantu ke abathi babona ngalelo langa abebechaza ngayo ke bechaza yena ke umsolo wesibili kuyitatimende noma ke bekhuluma ke ngazo i27 ka October 2014. Yebo kuyiqiniso.
Now, yesterday I had started on the evidence of Nthabise Mokete, and I had paraphrased some of her evidence and invited you to comment, but I'd like to start today with a proper premise by not paraphrasing but by reading from the transcript of her evidence and invite you to comment. And the evidence is contained in the transcript of the 26th of July 2023, and I'd start at page 25, which Advocate Baloyi says, yes, you may proceed, and Ms. Mokete. Now, there was a stage where there was a sound, a loud noise that sounded like a gunshot sound, a bang sound, like that of a firearm, whilst we were still in the car like that. Now I got shot. I then said to her that it is the sound of a firearm or a firearm that is being discharged. And Mrs. Mokete here, she's referring to Yolanda Nota that she was with in the car at the time. Should I proceed? Or you don't have your... Okay. Mr. Jonas, they are printing it for you. And then Advocate Baloyi says, if you say you said to her, who are you referring to? Mrs. Mokete, I'm referring to Yolanda Nota. Advocate Baloyi, yes. And then Mrs. Mokete. Now there was a person that passed or walked past at the time that I was saying to her that is a sound of a gunshot. This particular person, as he or she was passing, that he or she went past running. In fact, he was running as he was passing where we were. Then Advocate Baloyi, you say he or she. Did you see whether it was a male person or a female person? Miss Mokete, he looked like a male being. He had a pair of pants, lean built in terms of the physique. Advocate Baloyi. Now, from which direction to which direction was this person running past? Miss Mokete. Now, when I saw this person, the person had already passed the vehicle and he was running towards the park.
Must I comment?
Yes, because the comment that I want to invite, yesterday you gave, when I gave this, like I said, it was not quoting verbatim. You then responded by saying, yes, this lends credibility to one of the confessional statements of accused number 2, because he had said that he ran away after the first shot was fired. And by then we were referring to a person with dreadlocks. So my question was that, are you saying that the person that ran out at the time with dreadlocks was accused number 2?
Yes, but my comment insofar as yesterday is concerned, my lord, was in reference to the statement made by her, not her testimony before court, because I wasn't here.
Uma bengiphendula ke izolo mayelana nomuntu ke okuthiwa uyena kokuqala waphuma ke futhi egijima bekumayelana ke nestatement sakhe, hayi mayelana nobufakazi ke abethulile la enkantolo, ngoba ke ngenkathi yena sikhuluma ngaye ke uNthabise Mokete, ngenkathi ethula ubufakazi bakhe ke la enkantolo mina ngangingekho.
And the second question will be, the person that is described by Ms. Mokete after the firing of the first shot, he says it's a lean or slim person in physique. And importantly, she did not know where this person was running from, because as she looked, the person had already passed the car that she was in. Do you want to comment on that?
My lord, again, I was not before court. I can only comment insofar as what is contained in the statement. So it's a difficult situation to.
Okunye futhi ke akushoyo ke kubufakazi bakhe noma kushoyo ke yena ke uMiss Nthabise Mokete Mokete ukuthi ke uma esembona ke lo muntu umbone esendlulile emotweni, ukusho ukuthi ke akamazi ukuthi waye qhamuka ngakuphi noma ke ephuma kuphi, khona ongakusho kulokho. Cha, ngoba ke ngangingekho nkathi ke ethula ubufakazi, mina ke engikushoyo ngikhuluma mayelana nestatement sakhe, hayi ukuthi yini ayisho la enkantolo.
But you wouldn't have any reason to dispute her testimony that she did not see where the first person ran away from after the first shot was fired.
I will not dispute her testimony if that was put before court, because I was not here, my lord. That's the essence of what I'm saying.
Uma ukuthi ke nkathi ela enkantolo wathi uma lo muntu lo oqala ke noma lo muntu ke nkathi ke kusho noma isibhamu siqhuma koqala ukuthi wayebaleka ephuma kuphi, akukho ke ngakusho, ngeke ngikuphikise ngoba ke kwakubufakazi bakhe futhi ngangingekho la enkantolo.
And at page 26 of the same transcript of the 26th of July 2023, it will be at line around line 17. Ms. Mokete says, as we were busy arguing with each other like that, there was another sound of a firearm that is being discharged. And Advocate Baloyi says, now this second sound of a firearm that is being discharged, it sounded as though it was now close to the vehicle. The sound was closer to the vehicle. and it says Advocate Baloyi. I presume that the person that was talking, that the sound is closer to the vehicle is Ms. Mokete, but they wrote Mr. Baloyi. And below Mr. Baloyi says, yes, you may proceed, Ms. Mokete. Now, after that sound, the people that passed running towards the park in the same direction that the first person who passed running to. And Advocate Baloyi, I won't read that. We go to line 15. Mrs. Mokete says, now, as she opened the door, mind you, the people that we have already seen had run down the street. Then there was a third gun sound. Now, as she opened the door, I also tried to open the door because now the gunshot went for the third time.
We are both looking at the
Page 27, line
we are on 26.
6, 8, line 18. The way it says, now this second shot, go down. Yes. Yeah, that's one.
What's the problem now?
I think we were on page 26 now, but then Mr. Ramsey had passed page 26.
Oh,
You see from line 17,
Yes,
page
yes.
27.
Yes, I'm just going through it quickly, my lord. Yes, my lord, I see that, but if one looks at page 27 on top, that's the comment I can make. It starts by saying running towards the park, the same direction that the first person who passed running took.
So sorry, Brigadier, before you proceed, it will start from the last sentence on page 26 where Ms. Mokete says, now after that sound, two people passed running towards the park in the same direction that the first person who had passed running.
Indeed.
Mallet, just before Brigadier Gininda comments, we've allowed this cross-examination to continue, but the court will recall that at some point, I think it was Advocate Nisi objected to Brigadier Gininda giving an opinion and said he's usurping the function of the court. Now, here's evidence that is before court. Now, Brigadier Gininda is now invited to comment as to who is the person that is being referred to here. It's our submission that once evidence is before court, it's now for the parties to argue on the probabilities as to who the person is that is being referred to here. It cannot be left to the witness to then give an opinion as to who is the person that is being referred to here. At the end of the case, based on all the evidence that would have been tendered, based on the probabilities, it will be for us to argue as to who, in all probability, is the person that is being described here. It cannot be left to the witness, my lord, to give an opinion on that.
Le mbuzo ke ebuzayo ke manje bekuke kwanenkinga ke ngaphambilini lapho na ke uadvocate Mnisi ashilo ukuthi ke akusiyena ke ufakazi onganikeza uvo noma asho ke ukuthi ucabangani ngento eshiwo umunye ufakazi. Kodwa ke manje ngale mibuzayo ebuzwayo ke lapho khulunywa ke ngabantu noma umuntu owayegijima ke eya ngase park, akukwazeki ke ukuthi ke kungalindeleka ukuthi kube ufakazi onikeza ngalo lovo. Kodwa ke ngaphambilini bekunenkinga ke uma bekunombuzo okanjalo.
Yes, Mr. Admissibility.
As the court pleases, my lord, let me skip this part and go directly to what I said my purpose was. I was just giving the background of the sequence as testified by Ms. Mokete. But the main point that I wanted to come to is on page 26, she has already given a description of the first person that ran away past the car after the first shot, that he was lean in physique. Now the descriptor of the two other persons that ran thereafter, it's contained on page 34, and that's the sole reason why I embarked on this exercise, my lord. Not even so, sorry, I think I made you print the whole page. It's not page 34. Sorry, my lord, it's not on page 34. It's from page 45 to page 46 of the record of the 2607-2023, my lord. And that reference will be at line 15 of page 45. And it is Advocate Baloy saying, you mentioned that the first person was a shot that rang off and a person ran past, and you described the person. You mentioned that the second shot that rang off and two persons ran past towards the park. Are you able to describe those two persons? And Ms. Mokete says, no, I remember the very first person that ran past was tall, he was not short, also with a leaner physique or a slimmer physique. And then Mr. Bonis asked, is that the first person who ran past alone? And Ms. Mokete, the very first one who ran past alone. Yes, and the other two, Ms. Mokete, one of them was not, big in terms of the physique. He was neither lean as well. He was of average height, and I remember that he had dreadlocks. And at line 17, Ms. Mokete stated that now this other one, who was slightly bigger in physique, they did not outrun each other. They almost ran side by side, even though there was, and with a demonstration of fingers and in brackets written, that there was one that was a little in front of the other, and the very one with the bigger physique had a hoodie on his head, and with that head as well, he was taller. He was taller than the other two that I have already referred to. And he was asked by Mr. Balo, yes, any other description that you can give, Ms. Mokete? There is no other description that I can give. So essentially, the person that she described as wearing a hoodie is one of a bigger physique, not one of a leaner physique, according to her testimony here. And then she goes on to say, and with that head as well, he was taller. He was taller than the other two that I have already referred to.
My lord, my comment can only, as I've said, I think yesterday, can be perhaps twofolded. One, that the three suspects that Ms. Nthabiseng saw is corroborated in the confession of accused accused 2, in that he says he ran away after I think one and second shot were fired in the house. He went out. He then refers to accused 4 he leaves accused 3 inside according to the confession, and then accused 4 goes inside. So when he ran out to the car, that is according to the confession, my lord, he was running alone, and this is corroborated by this Ntabiseng, my lord. Thereafter, the second 2 people that Ntabiseng is referring to, my lord, identifies one person with dreadlocks whom it is alleged, my lord, or the investigation pointed that the accused 3, in terms of the investigation, is the person with dreadlocks on that specific day. Now, what we do not have, my lord, in the investigation is what accused 4 was wearing. The fact that the second suspect is described in the second grouping now as having a hoodie does not necessarily mean it's not accused 4, because I don't have a description and we did not find evidence indicating what was accused 4 wearing on that specific day, including accused number 1 and accused number 5. We can place them where they were, but we can't say, I don't have evidence to indicate what type of clothing was accused number 4 wearing on that specific day.
Lana ke uma echaza ke uNtabiseng uyasho ke ukuthi ke umuntu amshoyo owaye gqoke ke ihoodie uma emchaza ke ngomzimba uthi umuntu ke owayemkhulu ke ngomzimba engasiyena ke umuntu owayemncane futhi manje wena ke uthini ke ukuphendula lapho. Lokho ke kuyahambiselana nento ebhaliwe kusona istatement sakhe ke umsolo wesibili ungathi ke egonyuluka ushilo ukuthi uma isibhamu siqhuma okokuqala waphuma ke yena wabaleka washiya ke ngaphakathi umsolwa wesithathu futhi ke nophenyo liyasho ke ngoba ke uma sechazwa abantu ke laba besibili abaphumayo ke omunye uyachazwa ke ukuthi wayena dreadlocks uphenyo lothi esalenza lukhomba ke ukuthi umsolo wesithathu yena owayena dreadlocks ushilo ke nokuthi futhi ke uma esemshiya ke umsolo wesithathu ke ila khona ke umsolo wesine esengena ngaphakathi ke manje uma ekhuluma ke ngabantu ababili abalandela kamuva uNtabiseng lokho kuyahambisana ke naso istatement sakhe umsolo wesibili ukuthi ke uma sephuma ke manje kwaphuma kulandela umsolo wesithathu kanye ke nowesine ukuthi amchaze ke lo kulabo ababili ukuthi wayegqoke ihoodie anginabo ubufakazi yebo ngiyazi ukuthi wayekhona ke lapho bese endaweni zabo umsolo wesine anginabo ubufakazi ukuthi wayegqokeni ngokufanayo naye umsolo wokuqala ukuthi wayegqokeni nomsolo wesihlanu.
The only description of the alleged suspects, my lord, that is given by the witnesses is insofar as the person with the dreadlocks, where they describe the khaki or brownish jacket, Mr. Makeleni, I think we dealt with him, who identified or assisted rather in the identikit of the second suspect, where he described the black hoodie, which is corroborated by Mr. Zungu. So those are the recollection of the description in terms of the clothing that I recall. I don't recall having evidence that points to what exactly accused 4 was wearing, my lord.
Futhi ke lana esinabo ke noma ke ubufakazi ke esinabo ke ukumala nokuthi ke kwagqokweni yini ke egqokiwe lapho ukuthi ke yena ke uMr Makeleni owakelekelela ke nowasiza ke ngokuthi kudwetshwe le identikit mayelana ke nalo owayegqoke ihoodie kanye futhi ke naye ke uZungu owakhuluma ke ngayo ihoodie eyimnyama kodwa ke ukuthi umsolo wesine wayegqokeni anginabo lokho kufakazi lokho.
So that's how I could comment on that part, my lord.
Ilakho ke ngakusho ke mayela nalokho.
My lord, I just have one comment. I'm having a problem with the line of answering by the brigadier because he's making reference to my client. And there is no question that was asked by my colleague with reference to my client.
He's giving evidence.
To which question?
Which is asked, according to him, he's giving evidence.
I'm not happy.
It's a hypothetical situation. Listen to what I'm saying. If a witness testifies about 4 different people, and he says accused number 1 did this and this and this and that, and it is your client. Should he now, because he's your client, not testify about what number 1 did? He must now jump and say number 2 and 3 did this and this and this, and is that how you're reasoning it?
My lord, I'll leave it like that.
No, let's debate it. Is that how you are saying evidence should be led?
It was with respect to the questioning by my colleague.
Yes.
Mr. Ramsebet.
I don't control.
He stresses the point.
Hello?
He stresses the point with reference to my client. Instead of answering the question, a direct question that was asked to him.
Sir, they say you are stressing the point about his client.
No, my lord. If I may say, my lord, and this is what I'm saying, the question was put to me, and I started by saying a collaboration, my lord, which is contained in the confession statement of accused 2.
Yes.
And I'm saying, what is it that he's saying? It's not me. It's in the confession where accused 2 says, as he ran out, there was accused 4 who went in. I'm not stressing it is contained there, my lord. And I'm saying if you take that context and you take it to what Mr. Ramsipile referred me to, insofar as Ms. Mukiti is saying, I'm saying there's a collaboration. And that is why I'm saying, because we do not know what accused 4 was wearing, one can think that possibly it was him who's wearing a hoodie. That's why I was going with my answer. But I'm simply commenting or responding because the question is being put to me. And I have to comment about these 3 individuals whom Ms. Mukiti saw, and I'm talking about that collaboration, my lord.
Sikona-ke ukuthi ngiyagxila noma ngiyagcizelela-ke kuyena umsola wesine, kodwa-ke umbuzo engibuzwayo-ke bese-ke manje-ke kufanele ngikhuluma-ke ngaso istatimende sokugonyuluka esenziwa uyena umsola wesibili, ngikhathanisa-ke noma ngihlanganisa nakona lokhu engibuzwa ngako kuthiwa yikona ekushiwo uMs Mukiti. Ngithi-ke uma kwistatement sakho number 2 uyasho-ke ukuthi-ke number 4 wangena-ke ngaphakathi, so ngihlanganisa labantu abathathu uMs Mukiti akhuluma ngabo.
But Brigadier, if you listened to the objection by my colleague Advocate Baloyi, and hence I ran away from the passages that I was reading at the beginning and went for the description. I sought your description, your comment on the description as per Ms. Mukiti. Because Advocate Baloyi says, as to who Ms. Mukiti saw as the first person running, that is an argument that he will make at the end of the case. It is not your duty to draw inferences about the mind of Ms. Mukiti that this person that was running there, therefore exhibit H and JJ, Mukiti says it's that person. It's not her testimony. Hence, Mr. Numalo is not happy because you didn't answer even my question. You went on a drift to show that you can draw inferences, which is not your duty.
No, but my lord, that's not correct. I didn't even utter one word of inference. I was asked a specific question to comment about 3 individuals that Ms. Mukiti referred to.
Yes.
And my response was in relation to 3 individuals as per the confession of accused 2. So I don't understand where am I quoting it correctly, because the question from Mr. Ramsipile, it's in relation to 3 descriptions. I mean, the description given by Ms. Mukiti about 3 different people.
Yes.
And I'm drawing that inference from the confession of accused 2 that relates to 3 different people. How could I be, because then I don't know how to answer it, my lord, because I was asked a specific question and I answered it in that context.
Ngibuzwe umbuzo othize, lo mbuzo-ke futhi ngibuzwa-ke ngabantu abathathu uMs Mukiti akhuluma ngabo noma-ke abachazile. Ngase mina-ke ngiya kusona istatement lesi sakhe ngithi senziwa umsolwa wesibili. Yilokho-ke engiphendulile.
You see, you even use the word, you drew an inference from the statement of accused number 2. I was only asking you because other witnesses have described the person wearing a hoodie as a lean or slim person, tall, slim. Ms. Mukiti describes that person as the one with a bigger physique. That's the invitation I was calling for you to comment on.
No, my lord, again, I disagree. I think I was even fair to say, insofar as accused 4 is concerned, that I do not have evidence of what he was wearing on that specific day. But my response, my lord, was insofar as the 3 individuals that I'm being asked about, described by Mrs. Mukiti, I'm corroborating that with what is contained in the confession statement, not what I'm thinking or what I'm drawing or trying to think the investigation led me to. I was very specific to say this is what I'm being referred to insofar as Mrs. Mukiti is concerned, Ms. Mukiti, and this is what is contained in the confession statement of Mr. Ramsipile's client. It's specific. It's not an inference that I'm drawing. So my answer was based on those, my lord.
Ekuqaleni ngishilo ke ngaze ngasho ngathi angazi ukuthi wayegqokeni umsolo wesine, kodwa ke uma ngiphendula umbuzo ngalabantu abathathu abachazayo noma abashoyo yena ke uMiss Mukiti, ngase manje ngiyake ngihlanganisa naloko okubhaliwe kwistatement sakhe umsolwa wesibili, hayi ukuthi ngicabanga ukuthi, kodwa ke ngihlanganisa lokho akushoyo labantu abathathu abashoyo uMiss Mukiti kanye futhi naloko okubhaliwe kusona istatement sakhe umsolwa wesibili.
My lord, will be this an opportune time to take a short adjournment.
Okay, what's the time?
It's 27 minutes past 11.
Okay, 15 minutes.
Yes, my lord.
Thank you, my lord. I'm indebted. Brigadier, now just to tie up that point that we were engaging on before the break, are there any witness statements that say they saw suspects running away from the crime scene, that is the Khumalo household?
Yes, I think there is, my lord, but one will have to go through the first volume to be specific, so that we can go through them. We can share them. But I have a recollection of I think the ngashes or saying something to that effect, my lord.
Ngabe khona yini istatement zofakazi eshoyo ukuthi zabona abantu begijima bephuma emzini wakwaKhumalo? Yebo ikhona, kwafanele nje ngibhekeke ngicabanga ukuthi ke no onqatshe nabo ke bayakusho lokho.
And the late Mr. Mukiti as well, the one that we spoke about, I think he does talk about someone running away as well.
Mr.
Makaleni, sorry, the deceased, the one Makaleni, the one who assisted with the drafting of the ID kit for the second suspect.
Ukuthi nalona ke osewashona ke ubaba uMakeleni naye ke ulo wayelekelekayo ngobudwetshwa kwayo identity kit, naye uyasho ukuthi wabona umuntu ebaleka.
Did those witnesses specifically say or said, I saw suspects running away from 13511 Kutlanong Street, Mzamo section, Fosloras, on the 26th of October 2014 from between 2000 hours and 21:15 in the evening?
No, there's not even a single witness that says that, including the people who were in the house, my lord. Yes. They don't explain it in that context. Yes. No, there's no one who puts it specifically like that.
Ingabe labo fakazi yini bathi babona abantu bephuma kwa 13511 Kutlanong Street Mzamo section eFosloras ngazo i-26 October 2014 phakathi kwa isikhathi u8 ebusuku kanye ke no21:15. Cha, akekho ke oyibeka ngaleyo ndlela, ngisho nalaba imbala ababesendlini abayibeki kanjalo.
So what are those witnesses that you say you can check? What are they saying?
My lord, I think so that one does not misquote them. If I can be given an opportunity, I think we can embark on that exercise. Yes. But my recollection is like you'll have inference like saying Makhumalo's house or Kelly's house. You know, that's how they describe the crime scene.
Yes, I want that.
Yes, yeah, but I don't think there's even a single one in my mind that I recall that identifies the house in terms of the house number.
No, yes.
And the time. Yeah.
Hence I said in a generic form the crime scene.
Yes, no, in a generic form, my lord. I think we may find those statements. I'll just have to be given an opportunity so that
I'll give you that opportunity so that during the long adjournment, then we can revert to that after the long adjournment.
Okay, man.
Now, you will recall as well that before these particular accused persons were arrested, Mr. Mbata was arrested for this matter, and an identity parade was conducted in that for that suspect. You recall that?
I do recall, my lord.
Uzokhumbula ke ukuthi ke ngaphambi kokuthi laba abasolwa abaphambi kwenkantolo manje baboshwe kunomlisa ke uthize umbatha owaboshwa futhi ke kune ID parade eyenziwa ke, yebo ngiyakhumbula lokho.
And in this instance, specifically regarding accused number 2, after his arrest on the 16th of June 2020, why was an identity parade not conducted for him in respect of the people that were in the house?
My Lord, I do recall specific in two instances the two people that are interviewed, and that is Mr. Mtokozi Sitwala and Mr. Madala, who said they were 50-50. I think they put it in that context that they are not 100% sure that they will be able to do an identification parade. And I think I took their statements because I know they put it in the middle, so it wasn't going to take us anywhere. Insofar as the others, as I've said, my Lord, the investigation was procedural driven. You sit with the prosecution and you are guided as to which witnesses you can use or not. But those two specifically, I interviewed them, and they gave a statement to say they're not 100% sure. It's 50-50. I think that's how the statement is quoted.
Manje-ke uma eboshwa-ke umsola wesibili ngazo i-16 zikaJune 2020 kwakungani-ke kena-ke i-ID parade ingabi khona-ke. Ngiyakhumbula-ke umthokozisi Thwala kanye naye-ke uTumelo Madlala, futhi-ke kuney'tatimende zabo-ke engayibhala mayelana naloko, basho-ke ukuthi-ke uma ingenziwa-ke abanaso isiqiniseko sokuthi-ke bangakwazi-ke ukuthi bakhombe-ke basho ukuthi ilona-ke ngokumayelana nabanye-ke ngishilo ukuthi-ke uphenyo-ke uphenyo olwaluhola noma kukhulunyisana nabeshushisiki, kodwa bona bobabili labo basho kanjalo.
Now, regarding the rest of the people that were in the house, what decision and why was it taken that an ID parade, they shouldn't come to an identity parade where accused number 2 will be part of the people that are in the lineup, so that they can have an independent identification should they identify him at that parade, rather than what transpired here in court, him being identified from the dog.
My Lord, like I said, the first part, like I said, the two witnesses that are interviewed said they were not 100% certain, so they didn't rule out the possibility, but they also could not confirm that they will be able to identify the accused because of the period that it has taken. And as such, as I said, my Lord, I took statements to that effect. The others, as I said, it was procedural driven investigation. There were guidelines and given as to who we can use and who we cannot use. That's how far I can answer it, my Lord.
Manje-ke ngokumayelana nabanye-ke kwakungani-ke ukuthi banganikezwa-ke ithuba-ke noma ukuthi bahambe-ke bayokhomba-ke la umsola wesibili azoba khona-ke naye basho-ke kunalokho okwenzeka-ke la enkantolo ukuthi-ke bamkhombe bela enkantolo, bese ngishilo-ke ukuthi labo babili bona-ke basho-ke babengaqinisekisi ukuthi bangakhomba noma bangangakhombi, kodwa basho nje ukuthi abanaso nje isiqiniseko sokuthi-ke bangakwazi ukuthi bakwenze lokho. Abanye-ke ofakazi bese ngishilo futhi-ke ukuthi-ke kwakuxoxisana-ke noma ukukhulumisana-ke nabashushisiki kushiwo ukuthi ubani singabasebenzisa ubani esingabasebenzisi.
Now, if I may assist you, one of these statements, it's A126, and you can find one for yourself. I think A126 is in respect of Tumelo Madala, whom you took a statement from inquiring whether or not he will still be able to identify the perpetrators, and he said that this case has been a while back, the incident happening. Therefore, he was equivocal. In other words, he wasn't sure that he will be able to identify the persons that had allegedly entered the house on the 26th of October 2014.
Yes, my Lord, that's why I'm saying Tumelo Madala do recall, but it didn't say he will not be able to. It was just a middle line to say because of the time period, like you phrasing it, is not certain. It was a 50-50 type of response that he gave, my Lord.
Yebo ukuthumela Madala yena ngiyakhumbula-ke njengoba bengiqeda ukusho-ke, kodwa-ke ayibekanga ngale ndlela-ke oyibeka ngayo-ke, washo-ke ukuthi ngenxa yesikhathi akacabangi ngoba-ke kudala lesigameko senzeka.
Okay. Now, let's go back to the issue of the identity kit. We have seen Exhibit BB, which is the identity kit that was compiled on the 29th of October 2014. Did you, subsequent to that, request warrant officer still come to compile another identity kit regarding accused number 2,
Yes.
altering the image now that is Exhibit BB.
No. So the question is twofold, my lord. The first part, yes, I did contact Warrant Officer Steenkamp to assist with the photo that I had of accused 2 who was arrested. The second part, not to alter the initial identity kit. It was to say, this is the picture. If I recall, I think the picture was either coming from the identity document after accused 2 was arrested, my lord. And I asked her if she can take this picture and see if this picture, and if she puts a voodoo on accused 2, will it not be closely resemble the picture or the identity kit that was crafted on the 29th of October 2014. So that was that, but not to replace or alter. So you have 2 submissions. There's this identity kit of the 29th of October 2014, and when I asked her to assist with what I had in seeing that we can see similarities or not from her expertise, my lord. That's how I asked her.
Uma ngimcela ke u-Warrant Officer Steenkamp wakungasona ke ukuthi akashintsheke isithombe lesiyana noma i-identity leyana, kodwa kwakusemuva ke kokuthi eboshiwe umsolo wesibili nganginesithombe ke enganginaso ke ngimbuza noma ngimcela ukuthi manje uma esebenzisa lesi sithombe ngicabanga ukuthi ke sasibuya ke kuwena ke umazisi wakhe umsolo wesibili ukuthi uma ngasebenzisa lesi sithombe agqokise ke umsola ke noma umuntu loyo kuleso sithombe ihudi abone ukuthi khona yini angakuthola, hayi ukuthi ashintshe leya identity kit yayiseyikhona.
The essence of that request, my lord, was to try and ascertain from her whether she can link this photo that we've given to her when the hoodie is inserted with the photo that was crafted or drawn on the 29th of October 2014, my lord.
Manje ke imbangela ke noma kwakusemqoka ke kuleso sicelo kwakuwukuthi ke kulesi sithombe esimnikeza sona ke uma manje sesigqokiswe ke ihudi ngakwazi yini ukuthi ke manje abe khona kutholayo noma ke akuhlanganise ke nale identity kit eyayidwetshwe nge-29 ka October 2014.
Now your index number will be A154.
A154.
Yes. My lord, A154 is another report by Warrant Officer Steenkamp, Amanda Steenkamp, who is the facial image analyst, who also compiled the initial identity kit Exhibit J, from which Exhibit BB was extracted, my lord. And with leave of the court, my lord, once the brigadier has obtained the relevant document from his docket, I beg leave to take him through.
Yes, my lord, I do have 154, A154.
Okay. Now this report was commissioned on the 19th of June 2020 in East London. If you can assist me, Colonel, by going to the commissioning part, who the commissioner was, and the deponent is Amanda Yvonne Steenkamp.
Yes, I don't know this person, but it's someone from East London. It's A-Labes Strachen, looks like that, my lord.
Streicher.
It's Petros Paulos Globelar, yes.
Okay.
Globelar is a lieutenant colonel.
Okay.
Angimazi ke lo muntu ke ukuthi ke wase East London Commissioner of Oath, Petros Paulos Globelar, Lieutenant Colonel.
Yes, my lord.
I'm going to go through this, Brigadier, and there may have to be a time when we revisit it again, because I forgot in the morning to give it to my learned colleague so that he can scan it, so that the accused person, accused 2 in particular, could also view this identity kit as you are commenting on it, but I have already consulted with him regarding that. He's aware of this new identity kit, and by new I'm saying subsequent to the one of the 29th of October 2014.
Correct, understood, my lord.
And at page, there's no page number, but the second page will be, and I read, Phosphorus Cast 63610 of 2014, hereby I, Amanda Yvonne Steenkamp, under oath in English, paragraph 1, occupation and position in the South African Police. I am a warrant officer in the South African Police Force number, stationed at the Facial Identification Unit at the local Criminal Record Center in East London, where I am employed as a facial identification specialist with telephone number. Qualifications and experience: I have 28 years service in the South African Police. I am employed as a facial identification specialist at the South African Police Facial Identification Section since 1997. The functions I perform on a daily basis include the following: facial compilations, facial comparisons, facial mappings, two-dimensional facial reconstructions of decomposed bodies, and facial aging. I received training the facial identification functions at the CRC Training Center in Pretoria and facial identification expert status during 1998. I also gave presentation regarding facial comparisons and facial comparison at the Facial Comparison Symposium hosted at the School of Anatomical Science, University of the Witwatersrand on the 1st of March 2015. During 7 August to 13 September 2006, I gave evidence in the South Gauteng in the following cases: the case of State versus Nkoza and 4 others, a Middledrift case.
Sorry, why are you reciting all that?
Yes, so my lord, let me go to the relevant part, which is, I'll skip paragraph 3, that it should be mutatis mutandis with this paragraph, same paragraph in Exhibit J. The relevant paragraph is in paragraph 4. On 16 June 2020, I received a request from Colonel Gininda to do an alteration on an image by adding a hoodie and dreadlocks hairstyle to a person of interest. I performed the alteration using Adobe Photoshop C52 or CS2 by adding dreadlocks hairstyle and hoodie with a brush tool. Attached, please find Annexure A, the draft document in brackets that forms part of this affidavit, containing identity kits and control images. Paragraph 5 is the commissioning that we have just referred to. And then page 1, Annexure A, it reads: Phosphorus Cast 63610-2014. A facial composite is a method of establishing a visual likeness of any person through the verbal description of a witness or victim, and which is built up with the aid of identity equipment by a facial technician. The facial description must be established as well as the modus operandi of the sought person to aid the facial investigation. And it says, Annexure A is a draft document for investigation purposes. Page 2 is the suspect information of a person of interest, and page 3 is the identity key, control, and altered image. And page 2 thereof, it's Phosphorus Cast 63610-24. Mr. Makaleni, residing at Mzamo 3942, compiled the face of suspect B. He saw 3 unknown African males in the vicinity of the gas station busy on their cell phones. Later they saw them outside the house of Kumanos. He saw the suspect B at the gate and gave the following description: plus minus 25 years old, plus minus 1.80 meter tall, slender build, a golden inset in upper teeth, not sure in brackets regarding the golden inset in upper teeth, dreadlocks hairstyle, facial hair, mustache and beard. He saw something in his hand that, not sure if it was a firearm, witness could not compile the other faces. And there's an explanatory with second suspect, identity kit, unknown African male, plus minus 25 years old, slender build, height plus minus 1.80 meter tall, medium brown complexion, upper teeth, so a golden inlay in upper teeth, not sure which side, prominent cheekbones, dreadlock hairstyle, facial hair. And then, as you correctly say, Brigadier, the control image that was used, there are 3 images. The first on the left is the image that is of the image on the left in Exhibit J, and the one in the middle is the actual photo of an extract from accused number 2's ID. And then I think the last image is the one where it was now superimposed or altered using a hoodie.
Correct, my lord.
Yebo kuyiqiniso ukuthi kulezi ithombe intathu-ke esibhekile-ke lana, bese sokuqala ilena yokuqala-ke identity eyenziwa-ke noma-ke eyayenziwe, bese kuthi-ke ngaphakathi-ke nendawo isithombe-ke sona-ke esasetshenziswa esithathwa kuwona-ke umazisi wakhe umsolo wesibili. Esesithathu-ke ila khona-ke manje khona lesi kusetshenziswe lesi phakathi nendawo se-ID esegqokiswa i-hoodie.
And there's also this other one. Do you have it in front of you?
I think let me just confirm a lot. I have something like that, but it's just that the wording is written differently. But I do have something to this effect, similar to what you have, but I think it's the writing that is slightly different.
Yeah, because this one is an enlarged of this page, and it says this suspect was standing outside the gate, and the descriptors are the same as in the pages that I've read.
Yes, I'm not sure if. Let me see. I just don't see the word that we've seen, but the picture, yes, there is a picture resembling what I was shown, my lord.
Yes, like I'm saying, this exercise is going to be futile if it's not being there, so that there's no repetition when I ask you to comment on it. I was just placing it on record so that when it's placed there, I've already placed it on record. So I'm going to request that also this one could be done after lunch. I'll ask my learned colleague to scan it for us so that it can be built.
Understood,
Now, the questions that I can ask from this, whether or not we're going to build this, it's what was the necessity of having this second identification altered from DB to this other one now with a control image of his identification document used?
So my lord, there was no intention to alter, it was to compare. So that is the right context. The alteration is insofar as what was provided to warrant officer Steenkamp, and the altering she's talking about is what we provided to her, to put the hoodie and the dreadlocks as is described by Mr. Makalin, in order for her expertise. As I said, my lord, the purpose was to see if she can say photo B or the sample that we gave her corresponds with the identity that was taken on the 29th of October 2014. That was the purpose, to say you are an expert, you dealt with this identity on the 29th of October 2014. Here's the picture which does not have a dreadlocks of a person of interest. Can you then alter this picture that we're sending and add the hoodie and the dreadlocks and see if you can match the two? That was the purpose of this exercise, but not to alter the original identikit of 2014, because the comparison was being done in relation to that original identikit, my lord.
Inhloso ke yakhona konke lokho akuwukuthi ke unaso-ke lesi sithombe noma ke le identikit yange-29 ka-October 2014. Manje ke kunalesi sithombe ke sibuya kuyona ke umazisi wakhe ke umsolwa wesibili, ukuthi manje nangale ndlela ke uMakeleni asho ngayo usufake ke ama dreadlocks lawo kanye ke nehoodie, ubhekeke ukuthi yini kwakuqhathanisa nje, ubhekeke kulokho, kodwa kungasikona ukuthi ushintshe leya identikit yange-29 ka-October 2014, kodwa uqhathanisa uma manje sekufakwe ama dreadlocks kanye nehoodie.
So the purpose in essence, my lord, was to try and see if we can link conclusively accused to as per the photo that comes from his ID with the identity kit that was drawn on the 29th of October 2014. That was the purpose.
Inhloso ke kwakuwukuthi ke manje sibhekeke ukuthi singahlanganisa ngokuphelele yini ke kuyona ke identikit leyana eya nge-29 ka-October 2014 kanye nalesi sithombe ke esibuya kona ke umazisi wakhe umsolwa wesibili.
Or exclude him if, for example, the expect says no, there's no such in terms of her expertise, my lord.
Noma ke uma ungoti ethi ke cha kulokhu ke sengikwenzile ke lokho, kodwa ke ngiyathola noma ngiyabona ke ukuthi cha akuhlangani, bese ke eyakhishwa ke awukuthi nje ahlanganiswe, kodwa uma kuwukuthi akukho okutholakalayo akhishwe.
Where was accused number 2's identification document taken for it to be supplied to Mr. Nakanda?
It was taken by the arresting officers. As I said, when they arrested him on the said date, my lord, they did let me know. So it was electronically communicated as Warrant Officer Steenkamp was sitting in the western, not the western, the eastern Cape, East London, sorry, in East London, my lord.
Okwenzeka ke ukuthi noma umbuzo uthi ke watholakala kuphi ke mazisi wakhe umsolwa wesibili, amaphoyisa ke ambopha bangitshela ke base ke futhi ke bedlulisela ke na ngoba ke bakhuluma ke nami bedlulisela ke na ke Warrant Officer Steenkamp owayeseke East London.
And other than Makaleni, and whom we've established now that he's not the person that was in the house, is there any other person that made a statement to the effect that the second intruder wearing a hoodie also had dreadlocks, because the description of dreadlocks from the people in the house only related to the first intruder?
That is correct. All the people in the house relates to the first intruder with the dreadlocks. That's okay. That's what it says. I agree with you.
Yes, but my
Ngiyavumelana ke nawe kuyiqiniso ukuthi ke bonke abantu ababesendlini bathi lo owangena qala uyena owayena dreadlocks.
Yes, but my question is this: other than Makaleni, that we know that he was not in the house, are there any other witnesses that describe the person that they saw running wearing a hoodie, having a dreadlocks hairstyle?
My lord, I may speak under correction, but I seem to recall that the statement we dealt with before tea time, often Tabi saying, or the record, maybe saying something to that effect, but I'm not sure, my lord. All I can say with certainty is that the people who were in the house only describe the first intruder with dreadlocks, and they don't say the second one had dreadlocks and a hoodie. That's what I can say with certainty. Insofar as to whether there are other witnesses outside, one will have to be have an opportunity to go through all the witness statements and then give a certain answer, so that I don't seem to be saying something that contradicts the docket, my lord.
Ngaphandle kwakhe uMakeleni ingaba bakhona yini abanye ke kulaba ke ababe ngaphandle ke abashoyo noma ke abachaza ngalendlela ke uMakeleni amchaze ngayo ke ukuthi ke lo muntu wayifake ihoodie wayinama dreadlocks, laba ababesendlini bona ke mabechaza ke bachaza lo owangena qala ukuthi uyena nama dreadlocks, kodwa ke kulaba abangaphandle ke kuzofanele umuntu ke abheke ke manje kuzona zonke izitatimende ngingasho ke into engahambelani naloko okuyibhalwe kulona idokodo.
Now, Ms. Zandile Khumalo and Lieutenant Colonel Mangela testified about a reenactment that occurred around 2016 regarding the events that transpired on the 26th of October of 2014. Are you aware of that reconstruction that was conducted? That was before you even were seized with this matter.
The only construction, and I don't know if I assume, I'm assuming, my lord, and I stand under correction.
Yes.
The only thing that I seem to recall, it's where General Mukotedi and I think with Brigadier Mudise were involved, where they used actors to try and reconstruct the scene. I'm not sure if
That's the one I'm referring to.
Yeah, I have a recollection of that, my lord.
Ngiyakhumbula-ke noma-ke noma umbuzo-ke ukuthi-ke ngo-2016 kula khona-ke kwakuyobheka noma-ke kuyokwenziwa-ke kabusha noma-ke ukureconstructa yona-ke indawo yesigameko. Ngaba uyazini-ke ngaloko mayelana nesigameko leso esenzeka ngaso i-26 October 2014? Engikhumbulayo ukuthi kwakuGeneral Mukotedi kanye naye-ke uBrigadier Mudise. Ngiyazi ukuthi-ke basebenzisa-ke ama-actors. Yebo, yiloko-ke ebengikhuluma ngakho.
And the gist of Ms. Khumalo's testimony, Zandile, is that they were called to 13511 Kutlano Street, Muzamo section, for Sloras on that day, and using props, like you say, sort of an acting out and reenactment of that scene. Each person that was in the house in 2014 was called in to say, we've set up the scene, say this thing is Senzo, this one is the intruder, and explain how it transpired. But the gist of why I'm asking you this is, initially, I think at the beginning of the year, or even last year already, I had asked the state to provide us with a copy of the DVD of that reenactment, because I have a statement of a warrant officer Boysen who says he also attended that reenactment. He took videography of that reenactment, copied it into an SD card, and later made into DVD. And I haven't had the benefit of a positive response whether or not that DVD is still available.
My lord, I'll assist. I suppose then the defense wants to have access to that DVD, so I'll assist. I'll try to go through the electronic data that we receive with the docket when I sign for it and identify it and make it available to the defense. So I'll just have to go through the electronic data, my lord, that was given to us.
Ngingalekelela-ke lapho njengoba usho ukuthi kwakune-warrant officer Boysen othi naye-ke uyena-ke wayemthwebulike ngalelo langa lelo kwase kuba ne-DVD. Kuzofanele ukuthi ngiyobheka-ke uma ngilekeleleke ukuthi-ke nginikeze ngayo leyo DVD leyo.
That will be greatly appreciated, Brigadier.
No, I'll do my best, my lord.
Now, yesterday, because we were going up and down, I left, and when we were talking about the incident of the 18th of, we had spoken about the incident of the 17th of June 2020 at the boardroom in Pretoria North, where accused number 2 instructs me that you were present and you say you were not present. That will be something that will be argued, and what transpired in the boardroom. Then on the 18th, you go to Carltonville at Sibanye Gold, where accused number 2 was employed, and you said primarily to check on his alibi that he was at work at the time the incident took place. Is that correct?
That is correct, my lord, absolutely. But also just to go back on the date of the 17th, my lord, I seem to recall that it was said, I asked accused 2 to take off his clothing, I'm not so sure whether the
Yes.
top part, to check for tattoos.
Yes.
My lord, there will be no reason to do that because there is no statement in the docket, and that's why I said I was not there. But even if I park that, in the docket itself, there's no statement by either the people who were in the house or outside who give a description of tattoos. So that exercise, even if I was present, I wouldn't ask him to do that because there's no description that is given that the second suspect or even the first suspect had tattoos. You can just, the description in terms of the dreadlocks, the clothing goes insofar as that, but no description of tattoos was given, my lord.
Bese kuthi ke ngazo i-18 zika June 2020 wase biwa khona ke eCarltonville esibanye ukuyoqiniseka sake la ayesebenza khona ke noma la athi waye khona ke umsola. Kodwa ke ngicela nje ukuthi ngibuyele ke kuzona ke i17 ngoba ke khulunyiwe ke kwashiwo ukuthi ke ngazo i17 ngathi kumsola akakhumuleke eEthiopia ke kunubheka amathathu ngishilo ukuthi ngangile ngekho lapho kodwa ke noma ke ngingamanje ke nje lapho kuthiwe ngangikhona ke ukuthi yena ke ngimkhumulise ngithi ke ngibheka amathathu ngangeke ngikwenze sasingekho isidingo noma izathu sokwenza lokho ngoba asikho nesodwa istatement sabufakazi esakhuluma ngamathathu kwakhulunywa nje ngama dreadlocks naloko okwakugqokiwe akukho okwakhulunywa ngamathathu.
My Lord, I beg leave to approach accused number 2. His hand is raised.
Yeah.
Thank you, my Lord. I mean, that's it. Now, accused number 2, you stated that you then confronted accused number 2 with a copy of the identity kit exhibit BB, and you informed him that the person on the left with the hoodie bore a resemblance to him, right?
Yes, according to my observation. So I was basing that on my observation, my Lord.
Yebo ke uma ngiya kuyena ke umsolo wesibili ngithi ke lo muntu engimbona lana ke okulesi sithombe esidwetshiwe noma le identity ufana nawe ke lokho kwaku yiloko engangikubona mina.
And further that you then confronted him and said, I'm sitting with information that shows me that you are a person of interest or a suspect in the Senzo Meyiwa murder case, right?
Yes, I did, but that's not how the sequence is correct. But I think the sequencing is not accurate, my Lord. That was put at the beginning, after he was warned according to his rights, and that this assertion that he was, I'm sitting with information that he may be involved in the murder of Senzo Meyiwa, that was put at the beginning. Subsequent to that, then a response was given to me, my Lord, that no, he was not there. And I even alluded to the fact that, my Lord, it was interesting to me, or I find it interesting in that he was able to specify the specific date of this incident, the 26th of October 2014, that he was at work. And then subsequently, then we followed that alibi, which was found to be false. So that is the sequence that I'm laying. Thereafter, after the alibi was then denied, then the identity kit then kicks in terms of saying my view relating to the identity kit, which was also denied by accused number 2 in terms of him saying it's a mistaken identity. That's how it unfolded, my Lord, leading to the identity kit confrontation.
Mina ke ngizoyibeka noma ngizoyisho ke ngokulandelelana kwayo ukuthi kwenzeka kanjani ke kwakusekuqaleni ke uma ke la engangi mtshela khona ke ukuthi ke umuntu osolakalayo noma ke umsolwa ke kwisigameko sokubulawa kwakhe ke uSenzo Meyiwa ila asho khona ke ukuthi cha yena ke kwase kusho yena ke ukuthi ke cha ngalo lelo langa yi-26 zika October 2014 yena ke wayesemsebenzini yila manje sesiya khona ke emsebenzini ukuyoqinisekisa lokho uma sekutholakala ukuthi akusilona ke iqiniso yila khona sengikhipha khona ke manje isithombe noma phecelezi ke i-identity kit nayo ke aphika athi cha kwenziwa iphutha la.
And at Carltonville, where accused 2 was employed, you then attended upon 2 areas. One at Human Resources to find the cloaking records and other related documents regarding the status of whether or not accused number 2 was working first and whether he was at work on the 26th of October 2014, correct?
I don't recall, my lord, that it was two places. It was one facility,
Yes.
and Mr. Mulder, and Mr. Mulder was having access to the history in terms of the activities regarding accused 2 on the specific date we're inquiring about, and the activities of the cloaking record. That one will see that, my lord, that on the 22nd, when we finalize his affidavit contains the cloaking record of his movement around this period, my lord. So it was Mr. Mulder who actually was able to gain us access to those activities.
Umuntu ke owakwazike ukuthi ke asitholeleke noma ke asitholeleke isikhathi ke sokuthi noma ke ukuthi ke wayesemsebenzini ngalelo langa ke umsola wesibili nokuthi ke ukuhamba noma ke ukupropa kwenzeka kanjani ungena kanye nokuphuma emsebenzini kwakuyena ke uMr. Mulder.
Yes, when I say you went to two separate departments at Sibanye Gold, didn't you also attend to the hospital section also to obtain medical records for whatever purposes your investigation directed you to?
No, I don't recall that, my lord. The examination where I was present when accused 2 was examined was on the 22nd, after he made appearances on the charge of possession in Northwest, and subsequently then I think we went to Dr. Rhoqo. That's my recollection, and that is where the dental report was given.
Mina ke ngikhumbula engangikhona ke kwakungazo 22 kwakusemuva kokuthi ke bingelele imantshi ke umangalela enkantolo kwasekiwa kuyena ke khona eNorthwest kwasekiwa kuyena ke udokotela uHloqwe.
Now, just touching on that one, then we'll continue with this aspect of the visit to Sibanye Gold. The issue of the golden tooth, where accused 2 is now taken to Dr. Rhoqo. Other than Magaleni, the witnesses in the house who described a second intruder as tall, dark, wearing a hoodie, did they also describe that that intruder had a golden insert on his teeth?
No, my recollection, my lord, is that there may be one statement that identifies the first intruder as having a gold tooth, but then I think that statement was then supplemented by that person, I think, saying he's not sure. I think it could be Ms. Sandy Kumalo, but I stand under correction, but I can also, after lunch, be specific, my lord. But there is a statement to that effect, but it refers to the first intruder, that is insofar as the people who were inside the house.
Cabanga ukuthi ke sikhona ke istatement la abantu ke ababesendlini ke bashoyo ke ukuthi lo waqala ke waye nezinyo legolide, kodwa ngicabanga ukuthi ke kwakuyena uMzansi Khumalo, kodwa ke ngizobheka ke uqinisekisa ukuthi ikona ke lokho engikushoyo, kodwa ngicabanga ukuthi kamuva ke wayese esishintsha ke noma ke eyishintsha leyo nkulumo leyo.
Okay, now let's revert back to Carltonville. Accused number 2 instructs me that at Carltonville, indeed, he led the investigative team to his shaft where he worked, and cloaking records and other HR-related documents were obtained. And thereafter, he was taken to the hospital section because there was an issue to check whether the accused had had an injury during a mining accident that the investigative team wanted to follow. And if also I'm correct, Sergeant Mohane testified to that effect, that accused 2 was taken to the hospital section of the mining complex for that purpose.
My lord, if he was taken, and if Sergeant Mohane testified to that effect, it would have been before I arrived. When I arrived, as I said, my lord, the sequence of events were exactly as to where he was. Alibi followed, found to be false, identikit, which was then denied by him. I warned him according to his rights. Then as I was leaving, I was then called back by one of the members, and that led now to the confession, my lord. And after we had agreed that he is prepared to make a statement to an independent police officer, I departed with Sergeant Mohula. So there was no other activities where I went to attend to with accused number 2. The only encounter that I had with him, insofar as the medical section is concerned, it's with the doctor this Dr. Rhoqo on the 22nd. That was the following Monday of June 2020, my lord.
Uma kuwukuthi-ke uthi-ke uno Sergeant Mokgane wethule ubufakazi-ke mayelana nalokho ukuthi-ke bamhambisa-ke aya esibhedlela noma-ke emtholampilo khona lapho emayini, akuthi-ke lokho kwenzeka mhlampe ngingekafiki-ke mina-ke ngale ndlela engichaze ngayo ukuthi-ke kwenzekani, ukuthi-ke kuyobhekwa-ke ukuthi wayesemsebenzini kwatholakala ukuthi kwangasilona iqiniso lelo, ngase ngikhipha-ke isithombe noma-ke phecelezi-ke identikit naye IP-ka-ke uma sengihamba-ke yila ngibizwa khona elinye lamalunga ukuthi kutholakala ukuthi-ke khona-ke akusho lokho akusho-ke kwaholela ekuthini-ke manje sekufanele ayokwenza-ke istatimende sabe sesiyahamba-ke mina naye-ke umhula akukho okunye-ke engakwenza-ke kanye naye ngalelo langa.
Okay. Now, with respect to now that aspect of you arranging that a statement be obtained from accused number 2 because he had made certain utterances. Accused number 2 will testify, and he has already said in the trial, within the trial, that at Sibanye Gold, you did not confront him with Exhibit BB, the identity kit, but rather you confronted him with a photo that is part of Exhibit S, that will be photo 47, which depicts a red motor vehicle with persons around, and in the background on the other side of the car there is a person wearing blue clothing with a cap.
No, that's absolutely not correct, my lord. My lord, and I think I dealt with this part yesterday when I was dealing with the issue of the see-through bag. The downloads, insofar, because what he's referring to is contained in the downloads of accused number 3 cell phone. That picture with the red car, it's a sedan, and there are people appearing there. That picture, my lord, was found in the downloads of accused number 3. Now, I indicated that on the 16th, we were not in sight of accused 3, 4, and 5. It is after the confession of the 19th, and obviously him talking to me on the 18th and subsequently it being written down on the 19th and 24, that the analysis towards accused 3 in terms of the case number, the firearm that was seized from him, exhibits taken from him, were actually paid attention to. Now the statement from the downloader, this is now Sergeant Mabasa from Brixton, where the downloads of accused 3 were contained, was only made available or commissioned on the 17th of August 2020. So I could not have shown him, the essence of what I'm saying, my lord, I could not have shown him a photo that is contained in the downloads of accused 3 cell phone because I was not in possession of those downloads. The first data came to me around August 2017 when I received it from Sergeant Mabaso. Then subsequently, the analysis was done by Kenneth Stein. So that is not correct. I was not in possession of that picture.
Absolutely, ngiqiniso-ke uma ngabe ethi mina-ke angizange ngize noma-ke uma ngiza kuyena-ke ngeza-ke nginalesi sithombe lesi esasinemoto yobumvu kunabantu abami kuyona-ke kunomuntu ome ngasemuva-ke ogqoke iy'mpahla noma eziblue ngombala ngoba-ke okwenzeka ngaleso sikhathi leso-ke akukho enganginakho noma-ke engangikwazi noma okwakukhomba umsolo wesithathu, uwesine, umhlolo wesihlanu. Okwenzeka ukuthi leyo picture noma-ke leso sithombe akhuluma ngaso isithombe esikuma-downloads omakhalekhukhwini akhe umsolwa wesithathu. Futhi-ke istatimende engasithola sakhe uMabasa okuyena waseBrixton okuyena owenza lowo ma-downloads sangasithola ngeyi-17 zika-August ngo-2020. Ngaleso sikhathi leso-ke ngikhuluma naye umsolwa wesibili lawo ma-downloads lawo ngangingenawo.
And my lord, I even said that is why I had no knowledge of this see-through bag when we went to interview accused 3 on the 30th of June, because accused 3 was interviewed and measured on the 30th of June 2020, because I did not have that see-through bag picture and the linkages even when we went to interview him. So on the 17th or 18th rather, when I came across accused 2, I had no access to the downloads in that picture.
Futhi ke nanjengoba ke i-interview noma ke inhlolo khona engayenza naye umsolo wesithathu yayingeyipeti zika June 2020, akukho nangakhuluma naye mayelana naleliya saka ke lalinemali leli elibonakalayo ke noma ukubonayo ngaphakathi kulona ukuthi linani, ngoba ke lawo ma-downloads lawo ngangingenawo. Usho ukuthi ngazo i-18 zika June 2020 uma ngikhuluma naye umsolo wesibili, lawo ma-downloads lawo ngangingenawo noma lezo ithombe lezo ngangingenawo.
Let me just correct myself, Brigadier, because accused 2 has just mouthed to me to say, in fact, it was not at Carltonville when you confronted him with this photograph. It was at Pretoria North, SAPS, on the 17th of June 2020 in the boardroom. And he says specifically that it is you who showed him this picture with the person in the background with a cap with insignia that I cannot see, that is slightly bent, to say this person is accused number 2.
No, but my lord, that's misleading. That's not correct. The same explanation I gave applies to the 17th of June. As I said, the only time the name of accused 3 came into our picture was on the 18th, not even on the 17th, because I didn't see the accused on the 16th, accused 2. I didn't see him on the 16th, I didn't see him on the 17th. The only time I came across accused 2 for the first time was the 18th. So there is no way I would have shown him this picture on the 17th, because it was not even in possession of this team. We're not even aware, because accused 3 was not on site as part of the persons of interest. So it's not true, my lord.
Absolona iqiniso noma ke uye walungisa ke ummeli uthi cha, uye wamlungisa ke Msentanzi ukuthi cha, lesi sithombe lesi ke kwakungeyi-17 zika June 2020 ePretoria North kuleya boardroom la ubrigadier akutshengisa khona ke, uthi ke ubrigadier nalapho ke lokhu akuchazileke ngaphambi kuseyikona ke ukuthi ke ngeyi-16 akakubonanga, ngeyi-17 akakubonanga, kwakungeyi-18 zika June 2020 uma ekhuluma nawe ke la okokuqala khona ke manje esezwa ke ngaye umsolwa wesithathu noma ke ukhuluma ngaye umsolwa wesithathu, usho ukuthi ke ngazo i-17 zika June 2020 bangeke kwenzeke ukuthi wayengakhombisa lesi sithombe ngoba kwakungekho nje awayenakho noma awayekwazi ngaye umsolwa wesithathu.
Now on this particular picture, photo 47 of Exhibit S, during Constable Zungu's evidence, he was also led by my learned colleague, Advocate Baloyi, regarding this picture. And his testimony was on the 7th of September 2023, and it will be at page 10. And it will be the specific section that I want to go to is line 19 of page 10 going on to page 11 up to the top of page 12.
Yes, my lord. My lord, just to add on, to qualify what I was referring to with regard to the events of August. Now, in the statement which was discovered to the defense, A194 is the statement of Sergeant Mabasa, the downloader. Yes. Paragraph 5, my lord. In fact, even on this date, he was still doing the downloads. Paragraph 5 of A194 reads as follows, my lord. On 2020-08-17, at about 11:17, I received a CD from the phone downloads office with a computer folder marked Cleveland Case 962-2015. This is the case, my lord, when we're doing the analysis on accused 3, we picked him up on. I testify about this. Containing a phone download information. The computer folder contained 3 X-ray files that contain the information of 1 phone, 1 SIM card, and 1 memory card. The information in the XRY format cannot be tampered, edited, or manipulated. Paragraph 6. The information contained in XRY file was as follows: Samsung GT E2220, cell phone number 072-766-8169. This number, my lord, is the one that I said we're able to link it to accused 3, show that this was his downloads. Then there's email number 359796050297902, IMSI 65501224915137 and a memory card that belongs to Mthobisi Gadla Mncube, suspect linked to Phosphorus 636-10-2014 as directed by Colonel Gininda. That is the essence of what I'm saying, my lord, that these activities regarding this only took place later in August. So there is no way, and this picture that was displayed here, my lord, is contained here. So in June, I did not have access to this information. It was only made to me available later. So I could not have shown him this picture, my lord.
Kuloko aqeda ukufunda ke ubrigadier uchaza ke ukuthi lesi sithombe ke besitshengisiwe ke lana ngokwaloku okubhaliwe ke lana istatement sakhe uSergeant Mabasa u-A194 esiyasho ke ukuthi nge-17 zika-August ngo-2020 isikhathi kwaku-11:17 ngathola i-CD kuma-phone downloader kwi-ofisi ke ama-phone downloader yayine-computer folder eyayimakwe uCleveland Case 9602 2015 nemininingwane yokudownloada kwefoni kanye futhi ke i-computer folder leyo yayine XRY files amathathu ayinale mininingwane, ifoni eyodwa, iSIM card eyodwa kanye ne-memory card eyodwa. Futhi ke leyo information noma ulwazi olulapho kuleyo XRY alikwazi ke ukuthi ke lungashintshwa noma kube khona okwenziwayo kulona. Point 6 uthi ke information elapho kuleyo XRY file yile landelayo kwakuyi Samsung GT E2220 072 inumber 7668169 wasechaza ke ukuthi ke ileyo number leyo ke lesathola ke kuphenyo ukuthi kwakuyi number yakhe umsolo wesithathu we-IMEI 3597960502979902 kanye ne-IMSI number kanye futhi ke ne-memory card ekuyeka Mthobisi Gadla Mncube umsolwa ehlanganiswa necala uPhosphorus Case 636-10-2014. Uthi ke lokho ke ngithola ke kuyena ubrigadier Gininda bese chaza kubrigadier ukuthi iloko ke engikushoyo ukuthi ke ngalesikhathi kakhuluma ngaso umsolwa wesibili ngoJune noma i-17 zikaJuni ke lokhu ngangekabi nako kuse kwatholakala kamuva.
And this statement, my lord, just to end the last part, was then was made by Sergeant Mabaso and commissioned on 2020 August the 17th at 14:23, my lord.
Same day.
Yes, 17th August.
When he says he actually downloaded it.
Yes, same day, my lord. But it's August 2017. Same day, my lord. Yes.
Kodwa ke wasisi commissioner ngalelo langa ke ngazo i-17th August 2020.
My lord, it's just gone 1 o'clock. Is it an opportune time to take the lunch adjournment?
We have been until 2 then.